As many of you know, I'm a real estate attorney in North Carolina, and sometimes I think real estate law might get a bad rap as being boring, or people might think that transactional attorneys really don't get to do much real legal work. And I am here today to tell you a little bit more about what real estate closing attorneys do in North Carolina, more than just doing closings or sitting in the room with clients. And I would say the next most popular thing that we do is we're contacted to draft legal instruments called deeds, which is the conveyance of property from one party to another. Now, it may seem like preparing deeds is pretty simple, and it's not necessarily that the document itself is difficult to draft, but the most important thing about the deed is the legal description, and that controls what property is actually being conveyed. So if the legal description is defective, the whole instrument is defective, and the grantee may not be receiving what they actually think that they're getting. So that is without a doubt the most important thing that we do when drafting deeds, and it's making sure that that legal description is correct and what the parties intended to convey. Next, and this may be surprising to some people, is that we're often contacted by people that are interested in purchasing properties that are in foreclosure. And you might be wondering, well, okay, if someone's going to the courthouse to bid on a property, what would they call you before that? And the reason is you would want to do a title search. It's very prudent to do a title search on that property before bidding on it, because as the winner in a foreclosure auction, you take title to the property subject to any judgments, liens, encumbrances that were already on the property. So say the property owner had a judgment against them from some prior lawsuit that is still affecting the property. Once you win that property in the foreclosure auction, that judgment still applies, and they could still come after the property once you own it. So it's important to know what, if anything, affects the property outside of the foreclosure, because it will go along with the property. So that's something that we get contacted to do quite often. The next thing we're often contacted to do is title curative work. So that might be kind of a weird term. You may have not heard that before, but really it's curing title problems. And that could be anything from a defective legal description, or most commonly, say an estate was selling property and they didn't have all of the heirs execute the document, or say they missed having the executor join in the conveyance. That's really important, and if it's not done properly, then it could make the whole deed defective. Title curative work sometimes does involve some negotiation. That could be, trying to figure out whether the neighbor will allow the encroachment to remain or not. And you have to carefully consider who do you want to pay to be doing that negotiating, because document drafting most often, at least in our office, is a flat fee because we have an idea of the scope and the time that it will take. But work outside of that is generally by the hour. So most people know lawyers get paid by the hour for most things. So if a lawyer is engaging in negotiation on your behalf, then you could easily rack up a lot of charges for that. So I always like to advise clients that, hey, yes, we can prepare this document for you. If it is signed, it will do what you need it to do legally, but you may not want us to be the one that is trying very hard to convince all these people to sign. The next thing is not necessarily specifically a real estate attorney practice, but it can be, and that is entity formation. A lot of real estate attorneys will engage in helping clients form entities and prepare organizational documents because those entities are so often used to purchase property. And it can be much more efficient to have one attorney handle all of those things if that attorney is knowledgeable in entity formation and that you have a good CPA that's guiding you as to what elections to make for tax purposes. The next reason that you would call a real estate attorney is if you just need a consultation to talk through an issue or something that you may feel will become an issue that's real estate related. And most often this is because an easement is needed, or it exists and isn't being used, or is being used outside of its scope, or some other dispute with a neighbor. So what you're doing when you get a consult with an attorney is you're buying their time to talk through the issue. You're really just using that time to learn from their experience and have them guide you through whatever that dispute is. So if you're a new lawyer getting into real estate and you don't want to do consults, just make that clear up front. But otherwise, expect that you will get a lot of calls from people who have issues with their neighbors. My late law partner, I listened into a consult that he had one time, and The issue was the neighbor, the caller was upset that the neighbor was not pulling in their trash cans on time. And my law partner said, "Tell me about your neighbor. What's going on with them?" And they said, "Well, it's a young couple. They just had a baby. The husband's out of town a lot, and they're just not getting their trash can pulled in on time." And his advice to them was, "You may have wasted your money, but my advice to you is to go over and say, 'Hey, I know that you're new parents struggling and you've got a lot of things on your plate. Do you mind if I pull your trash can up for you?'" So rather than, don't make an issue out of nothing, you maybe try to talk to the neighbor. This is not a legal issue. This is an interpersonal issue. And he said thanks and sent them on their way. So sometimes consults can be like that, but more often than not, they are true legal issues.
Did he charge him?
Oh, yeah. Yeah, that's payment up front. And they were like, "Well, we didn't use the whole hour." He said, "It's not for the hour. It's for your question." So these are the types of things that real estate lawyers do outside of just closings. And there are a few things that people call real estate attorneys for that may not be the best fit for a real estate attorney. In our practice at Thomas & Weber, we get a lot of phone calls for landlord-tenant disputes. And we almost always refer those to litigation attorneys. And the reason is litigation attorneys are better suited to carry out the dispute to court, because often that's where those are headed. If we knew that the only thing that this client may need is a letter and it's going to go away, yeah, maybe we would be involved, but we like to look at the client's issue as a whole. What we don't want to do is to tell a client, "Sure, we will write this letter, we'll send it off to your tenant or to your landlord or to whomever it needs to go to." But then we know that the likelihood of this issue settling or resolving without litigation is minimal. We don't like to then say, "Okay, well, that's as far as we will take it, and now you need to go to a litigation attorney." So you may be wondering, well, why won't we just take it to litigation? And that is because a litigation schedule and a closing calendar do not mesh very well. In litigation, the court determines your schedule. You are at the mercy of the judge and the judge's calendar. So if the judge says you need to be at this hearing on this day at this time, it does not matter what closings you have on your schedule. And because our focus is real estate closings, we want to make sure that we can honor the schedule that we have set up with the buyers so that they can close on time, not have to worry about whether they can get their keys or move into their new home because we are having to rush to court to handle some litigation matter. So at least in our practice, we tend to refer out landlord-tenant because those disputes can often end up in litigation. And then another thing we get called about often that a real estate attorney may not be best suited for is protecting your home in bankruptcy. We'll have a lot of people that are, looking at filing bankruptcy and they're concerned about what will happen to their primary residence. It's very easy to think, okay, I'm worried about my house, so I need to call a real estate lawyer. But what they really need to do is call a bankruptcy attorney. And so we often caution or refer out those people to bankruptcy attorneys so that they can have someone that can advise them on the whole picture and get them the best advice that they need, because we are not the best suited to that. Some real estate attorneys may have multiple practice areas that they do. Our office in particular, we focus on real estate. We don't do bankruptcy. We don't do litigation. So these are the types of things that if you're focusing solely on real estate, what you can expect to do day to day and what you can expect to help clients with. I'm Tiffany Weber, again, real estate attorney in Mooresville, North Carolina at Thomas & Weber. Hopefully you learned a little something about what you do as a real estate attorney, and I will catch you in the next video.